Sometimes we forget why we're here. It's easy to fall off track. These help us remember.
These battle scars don't look like they're faded, don't look like they're ever gone away. They ain't never gonna change. These battles.
Growing up, I had a dream, something no one else could see. Tell me what it means when your faith is falling beneath your knees and you can't breathe. Everything you see reminds you of what you're not or something you won't be. You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians or choose to be an accountant because it's safe in a business. Not because they wanna do it, just because they heard it pays. And who the fuck wants to be poor knowing that's how we've been raised? Society is getting heavy, I can feel the weight. The pressure of success is like 100 million pounds of shame. And that's the reason I'm staying up late, trying to find a way to escape the stereotypes this day and age is making me feel like the only way I'll be happy is getting signed to a label and making money through rapping. I wanna share my emotion because this world is attacking the very principle of life that lets the people be happy. If you don't have a reason to breathe, why even live? These battle scars are impressions of everything that it is.
Scars don't look like they're faded, don't look like they're ever gone away. They ain't never gonna change. These battle scars don't look like they're faded, don't look like they're ever gone away. They ain't never gonna change. These battles.
Now, if I had a voice that reached 100 million people, I'd tell them there's a reason that we're all created equal. Cause some decide to be great and some decide a sequel to an average person's life is simply what they want to be. So you make your decision, all I know is what I'm given. Won't define the life I lead or the way I dwell in existence. I've seen a greater image on the walls of where I'm living, and the words twisted and scripted remind me of something written. Faith is a gift that is given down to the people. If one believes it, one receives it. It's given if it is needed. Don't ever think you're trapped in a life that you never wanted. Your options are infinite, that's some mathematical logic. I'm not saying I'm a prophet, I'm speaking for what it's worth. These lyrics define my prayers and these battle scars on my church. Not saying I'm a prophet, I'm speaking for what it's worth. These lyrics define my prayers, these battle scars on my church.
Scars don't look like they're faded, don't look like they're ever gone away. They ain't never gonna change. These battle scars don't look like they're faded, don't look like they're ever gone away. They ain't never gonna change. These battles.
Oh, I didn't even expect. Oh my god, my face is like huge in the screen. Okay. And I look like I have some crazy hair. How are you guys doing? The reason the perspective is a little off, let me see if I can back this off a little, is I had to bring, I think I'm going to have to do it through my main camera. So for now, I'm just going to be big head. I had to bring my equipment with me to Pennsylvania to do the Ladies of Liberty. So I had to reset up everything really quickly in order to do the show. And those of you who are closer to me, you know, either we talk personally or you follow me on Twitter, know, I mean, anyone watching the show knows that I was really sick, maybe, was it 3-4 weeks ago? While I'm not technically quote unquote sick, I'm not like contagious or anything like that, I'm not over it. I am so tired that I could barely stay up. And yes, I only have fingernail polish on one hand because that's all I had time to do. So deal with it. Sometimes that's just the way it is. But I'm like, you know, you can make excuses like it's 10 o'clock at night and I've been working on bylaws all night, so maybe don't do a show tonight. Yeah, there's always those excuses and I need to get back in the saddle. So, and it's heavy convention season, which is already very difficult for me. So I decided we are going to just get right into it. But what I haven't done in a while is my sponsorships. And remember, let's do the YouTube stuff, and I'm going to do some of my sponsorships. And you can see, oh, it's this side. I finally was able to get that Band-Aid off my face, and now I'm just waiting for that to heal. But boy, this lighting in here is not very attractive tonight, particularly with the way I feel. So you're just going to have to put up with my ugly mug. But first of all, let me see if I even remember how to do this. It's been so long. Subscribe! Subscribe! If you don't subscribe to the channel, baby Jesus will cry. And you don't want to make baby Jesus cry, do you? No, of course not. Also, please follow me on X Twitter, Karen Anna Harlow, spelled unusually. You can see it right there. On the bottom screen. I'd really appreciate it. I think I'm at like 26,500 followers, which is pretty nice. And last but not least, I really could use your support on Patreon, which is patreon.com/Pink Flame of Liberty. Speaking of patrons, most people do not take advantage of the patron benefits. I know I hardly ever participate in the Discord I have for the channel. I'm really gonna try to do that more. So if you're a patron and you're not in my Discord, you know, please shoot me an email, pinkflameofliberty@gmail.com. We'll get you in there. I'm trying to post more in there. It's just that I do so much. But my top level patrons can also have periodic product advertisements or your special project that you might have, as long as it's liberty oriented. And other levels do get a free t-shirt out of my store each year. And I do have the Afuera shirt in there, which has been popular. I need to buy one for myself. I'm wearing not something from my store today, but I just love this shirt. I got to show you guys. This is from the Hunger Games. Remember who the enemy is. The enemy is the state. State speech is hate speech. That's another shirt in my store, by the way. But long time top tier patron is Sean Dempsey, who has written 2 children's books, The Tale of Two Brothers. You can get them both on Amazon, and Ava in the Storm. He is a libertarian out of New Hampshire. These are beautifully illustrated. Let me see if we can, let's get one from Ava in the Storm here. You just see, it's just cute little pictures. So highly recommend these for the young people in your life. And they're actually really good stories if you happen to have a child that likes to be read to and shown the pictures. These are fantastic. Also, though, if you don't want to become a patron, but you just wish to have some product placement, get in touch and we will discuss it. I would really appreciate it. But again, my bread and butter for at least this show comes from patreon.com/Pink Flame of Liberty. Okay, that will be it for this evening on that kind of stuff. Let's get right to the Supreme Court decision. I realize I haven't done much party history lately either. And oh, if you've noticed, my hair is like a slightly different shade of pink. Yeah, I tried a new brand. I think I like this color better. I think this is a much hotter pink, but it's very uneven in its application. I don't know if you can see, like, see how it didn't cover the roots as well. But anyway, I brush it so it's not quite so crazy. I do like this color better. It is The Good Die Young, DYE. Anyway, 9-0 decision from the Supreme Court. I want to give a little intro on this. If you want to go back on my channel, I did 2 shows after the Colorado Supreme Court decision and really delved into Article 3, 14th Amendment, Article 3. And my particular interest was whether or not the president is an officer of the United States. And I really, really wanted the Supreme Court to opine upon that, because that was just such an obscure thing. That's like such a parliamentarian thing to really be interested in. Most people were really, really upset over the And I'm upset over the lack of due process too, don't get me wrong, but that's kind of like an obvious thing. So they were more upset over the lack of due process, over whether or not he really did incite an insurrection, which you all know my opinion is absolutely freaking not, unless you're going to say all the Black Lives Matter people were insurrectionists as well. And I would also say, not popular as an anarchist, you say insurrection as if it's a bad thing. But putting all of that aside, I didn't dwell on that. Enough people were dwelling on that. I was dwelling more on the technical language of office versus officer, which ironically I was dealing with tonight with some state party bylaws, which are fantastically vague on that point, almost as vague as the 14th Amendment. I should have made that analogy. But alas, the Supreme Court did not deal with that. And I was talking with JJ, hi JJ, I do see you there, earlier today, on how when I heard that the Supreme Court really only dealt with a very narrow issue, I was mad. I was mad before I even read the decision. I heard about it and I got mad. And I was talking with JJ earlier about how I realized how dumb that is to get mad about something before you even read it. But isn't that the state of the world today? We'll see the headline of an article and it'll just make us mad, and we haven't even read it yet. Or you'll see something on Twitter. I love on Twitter when you're about to comment on something and the little box comes up and says, would you like to read the article first? Which is really interesting. It just goes to show, and The Righteous Mind deals with that. Those of you who have read that book, that we're constantly seeking post hoc justifications for things that we already believe. So anyway, I went into reading this prepared to be really mad that they didn't deal with my pet issue. And after reading it, and you notice I did do my highlights, I realized that was dumb. It was selfish. I still would have loved for them to deal with that issue. But in reading, and I know they're not technically dissents, so there's a majority opinion, and then there are some concurring opinions. And concurring opinions are not dissents, but the reason why they wrote concurring opinions, which will be dealt with in the majority opinion, is that they didn't agree entirely with the reasoning of the majority opinion. And I'm going to analogize this to a mistake I think that was made in the Judicial Committee on my now voided removal from last term. I don't think in the way the LNC presented that motion that the counts, my bill of particulars of all of my awful crimes, I don't think they were divisible. I think they presented them as this is it, and if any one of them failed, the whole thing failed. Now the JC disagreed with that because the LNC could have voted to divide them, and they did not. And the JC didn't agree that if one failed, they all failed. And the one they agreed failed is that dumbass past LNC, and I will say it, and of course it's not everybody, it was the ones that voted for it, without dividing the question, tried to say I violated the membership pledge, because words are violence, don't you know? How hard am I hurting you with my words? Show me on the Statue of Liberty where my words are hurting you. But anyway, the JC did in fact say I did not commit word violence. So in my opinion, the whole thing should have been overturned. I'm going to analogize here is that maybe in support of the JC deciding it didn't matter if one of them failed, they kind of said the same thing here in this Supreme Court decision, that any one of the various counts various rationales was enough to sustain the decision. So it didn't matter that not all 9 justices agreed with every argument. That even one of the arguments being correct was enough to justify the decision. So the concurring opinions are kind of partial dissents, in my opinion, disguised as concurring opinions, because they are dissenting with some of the reasoning. Now, I would say in my case, the LNC made it clear it was a cumulative case and didn't say that just any one of those things would have been sufficient. But we're not gonna get back into that. But that was just an interesting analogy, very inside baseball. So we're going to go through the majority opinion, at least the things that I found interesting, but then we're going to get into the concurring opinions. And that's where I stopped being mad. The concurring opinions, where they dissented, let me summarize it for you. They thought the majority opinion covered far too much and that it could have answered the question without going off into the weeds. And here I was mad that they didn't go into the weeds even further. But after reading the concurring opinions, I think they're right. I think the majority opinion did go further than it needed to go to decide the question. And why is that a bad thing? You might think it's a good thing because, oh my God, it sets some additional precedent. But you want to know what? Each case is so fact-specific that it becomes easy to set a precedent that really doesn't apply to a future case because of even just a mildly differing fact, yet it gets all lawyered up, and even lay people will go on to say that it's precedent when it's not. So now I'm no longer mad. Even though I still want to know the answer to that question, I am convinced that the president is not an officer of the United States. If you want to know why, my constitutional argument why, you can go to those other videos. If I remember, I'll stick them up in the high bar, but you know I always forget, so don't count on that. Just do a search for the word Trump in my channel, and you should be able to find it. And just for the record, because I know I have some new watchers here, because I actually have quite a few people watching this. This is like one of my highest viewer counts. I'm not a Trump fan. I am the National Secretary of the Libertarian Party. I am a Libertarian fan, but my background is I am a registered parliamentarian, so I'm interested in procedure, but I'm also a 30-year paralegal. So very interested in legal things. So let's go this over. Let's go over this. Are you ready? Got on my old lady glasses, my funky glasses. So just to cut to the chase, as it were, says a group of Colorado voters, shame on Colorado and shame on the Colorado Supreme Court. And I say this as not being a Trump fan. And I'm going to say something very interesting, though, that can be used for the Libertarian Party here later. So a group of Colorado voters contends that Section 3 of the 14th Amendment. Did I say Section 4 before? I meant Section 3. So sorry for that. And a reminder to everyone in chat, all super chats matter, because half of my videos get demonetized. And by the way, for smaller channels like mine, YouTube monetization means like $6 a month. Like, nobody's getting rich off of it. It's the big channels that make the big money. A group of Colorado voters contends that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald J. Trump, who seeks the presidential nomination of the Republican Party in this year's election, from becoming president again. The Colorado Supreme Court agreed with that contention. We went over their decision. It sucked. It sucked so bad that it was like a black hole, sucking all the matter of Colorado into it. And Jenna Griswold, cry harder. You know what? You've inspired me. I am seriously considering running against you. Not that I probably have a chance as a libertarian, but that's actually like an office that I'm very interested in and have a background that makes me I have qualifications, so let's put it that way. But boo-hoo, Jenna Griswold. Cry, cry, cry. Anyway, it ordered the Colorado Secretary of State to exclude the former president from the Republican primary ballot in the state and to disregard any write-in votes that Colorado voters might cast for him. Former President Trump challenges that decision on several grounds. Because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates, we reverse. So that's cutting to the chase. Those of you not as familiar with me, a point of trivia, when it comes to ballots and the Secretary of State, the former Secretary of State, was it Wayne Williams? I sued him, and it went to federal court. Didn't go to the Colorado Supreme Court, but it did go to federal court because it was a constitutional question in Colorado. I am one of the three petitioners, plaintiffs in Colorado that successfully challenged the ballot selfie law in 2016. Actually, maybe there was 4 plaintiffs. There was a Republican, a Libertarian. Was there a Green person? Green Party? I don't think so. I think there was just an independent. So we were the ones that won the right to take a picture of your ballot. Let me see if I can find. I know I always go a little off track here, but just in case you all ever want to read this, it's such an interesting case, and you. So here's an article you can read on it. I'm going to share it on the screen here if I can get this to come up. This is so weird. For some reason, pictures don't want to come up. Let me hit. Very strange. Well, anyway, you can still read about it. Let me change my screen here. So you can go to the Colorado Independent. There used to be a big-ass picture of me right here. I don't know what happened to it. How a Libertarian plans to challenge Colorado's ballot selfie law. So you can read here, Karen Ann Harlos, the pink-haired spokeswoman, because I used to be communications director at that time. Colorado's growing Libertarian Party wants to make a video of herself filling out her mail-in ballot, explaining why she's voting for Gary Johnson for president. So, anyway, you can read about that. Just figured that was a point of trivia. I did a thing, not just a talker. I'm also a doer. Okay, so let's go to some more highlights in this decision, shall we? So it says, after a 5-day trial, the state district court found that former President Trump had engaged in insurrection. God, that is just such crap of the bull. That was... If that was an insurrection that this country was actually threatened by, we don't deserve to exist. If a bunch of people taking selfies in the Capitol with some of them looking like they were rejects from a Village People like convention or tryout or impersonators is just silly. Yeah, there was quote unquote violence. There's violence at nearly every riot. The only person killed was a protester by a trigger happy Capitol Police person. Well, do you want to talk about the violence at the BLM riots? Do we want to talk about that and say that anyone that was involved in that was an insurrectionist? Do we want to go there? Because if we want to be fair, let's go there too. But the fact is, I don't think any of them were insurrections. Anyway, but nonetheless denied the respondent's petition. The court held that Section 3 did not apply because the presidency, which Section 3 does not mention by name, is not an office under the United States, and the president is not an officer of the United States within the meaning of that provision. And that is what I was really, really interested in. But they ended up not touching that. Anyway, so I see JJ was laughing at the Village People thing. The QAnon shaman, he's one of the ones that I include in that. He's actually a libertarian now. and he's running for office in Arizona. I did get to meet him at the Arizona convention, but I did not take a picture because he did not have the horns on. No horns, no picture. Sorry, you're not the shaman without the horns. I would have taken a picture of him if he had the horns on. Anyway. Sorry, I still got a bad cough. And when I get too exuberant, which is kind of like my natural state. So it says, we granted former President Trump's petition for certiorari, which raised a single question. So this is the only question raised in the petition for cert. The Supreme Court should be very limited in only answering the question raised in the cert. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Okay. Concluding that it did, we now reverse. And of course, I obviously think that's the right decision. I thought what Colorado did was complete horse patooky, and what Maine did was as well. So this is the right decision. Pleasantly surprised it was 9-0. Though again, there are some shots fired in the concurring opinions. It gives a little bit of a history of the 14th Amendment. I like to analogize this to bylaws, because amendments to the Constitution are relics of national trauma. A lot of times weird ass amendments to bylaws, I call them relics of institutional trauma. There are some things in the 14th Amendment that are great, like, you know, they were dealing with the issue of slavery, but I think it went entirely too far in dealing with a time-bound situation, and we are now seeing the problems of applying that to modern-day situations. So, proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment, and here's where I got mixed feelings. You all know I'm not a constitutionalist to begin with. I don't believe any. We're not going to even get into that. Let's just say I'm not a constitutionalist. But I have mixed feelings about the 14th Amendment. I have some really good ones and some really bad ones. And here's where the tension comes in. The 14th Amendment expended federal power at the expense of state autonomy. I don't like that. Even though I like some of the things the 14th Amendment did, I don't like that it was put us well on our road to not being the form of country that we were founded upon being. It centralized the power rather than it being more a confederation of states, and thus fundamentally altered the balance of state and federal power struck by the Constitution. And I understand why. Slavery was an evil that had to be dealt with. But this did, we are nowhere near or like what we were founded to be. And I think that's because at the founding of the country, they should have done away with slavery right from the beginning. But they didn't want to do that. They took the expedient route and figured it would eventually go away. And I tend to think that was a fatal wound. I think we were doomed from the womb by the fact that we were founded as a country of freedom, but yet still claimed to be able to own other human beings. I've went off on this before, and I think this is just starting to show the historical ripple effects of not having the testicular fortitude to stop that evil practice at the very founding of this country. Anyway. Section 3 of the amendment likewise restricts state autonomy, but through different means. It was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. And then it goes on to quote some people who are arguing in favor of this: yelling secessionists and hissing copperheads. I don't know. I mean, obviously, I do not agree with the reason for secession, but I agree with the right to secede. I believe every state has the right to secede. It is a terrible thing that they seceded over such an evil practice because it kind of ruins secession for the rest of us. So Section 3 works by imposing on certain individuals a preventative and severe penalty, disqualification from holding a wide array of offices, rather than by granting rights to all. Now, what's interesting here is the way the Supreme Court described this as a severe penalty. If you remember in the Colorado Supreme Court decision, they kind of said, due process isn't required because they almost made it a triviality, like, oh, well, you don't have a right to run for president. So what do you really, like, what life, liberty, or property is being taken away from you that you actually deserve due process? And I found that so repellent. So they didn't deal with that quote directly here, but I think that is a little bit of a shot at that quote from the Colorado Supreme Court, that this is, in fact, a severe penalty. It is therefore necessary, as Chief Justice Chase concluded, and the Colorado Supreme Court itself recognized, to ascertain what particular individuals are embraced. And then they go on to say the Constitution empowers Congress to prescribe how these determinations are made. The relevant provision is Section 5. Now, we did not deal with Section 5, to my recollection, at all in my Trump videos. And it is this straying over into Section 5 that the concurring opinions have disagreements with, which enables Congress, subject of course to judicial review, to pass appropriate legislation to enforce the 14th Amendment. Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation, less than a year after ratification, Senator Trumbull noted that notwithstanding Section 3, hundreds of men were holding office in violation of its terms. Excuse me. The Constitution, Trumbull noted, provided no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. The enforcement mechanism Trumbull championed was later enacted as part of the Enforcement Act of 1870, so after the ratification of the 14th Amendment, pursuant to the power conferred by Section 5 of the 14th Amendment. That reasoning seems solid, but they didn't need to go there, is what the concurring opinions will state. And of course, again, I still see a lot of watchers. Please comment. I love your comments. It helps me think, because I'm very ambivalent about a lot of these things. And in the Trump videos, I didn't even know what my conclusion was going to be when I started. And then I read through the decision and came to the conclusion that I came to. So your comments really, I really enjoy them, and they help me. This case raises the questions whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. And this is what the concurring opinion said. This is really all they needed to say. They didn't need to stray into Section 5. In particular, the states enjoy sovereign power to prescribe the qualifications of their own officers. It's interesting. It almost implies there, though, that the president is an officer of the United States, though they don't say it. You know I wanted them to discuss that. And the manner of their election, free from external interference, except so far as plainly provided by the Constitution of the United States. What's interesting here is now, I agree with the external interference, by the way, but we, as the Libertarian Party, have taken ballot access cases to the Supreme Court to try to enforce some kind of fairness upon the way the states enforce election law. Ballot access laws and the like, are enforced or enacted by the duopoly, who have a vested interest in keeping themselves in power and have been screwing over third parties for like ever. And yeah, Ricky Mendoza's correct. I just saw that. Nothing ever happened to that trigger happy officer that shot, crap, I'm forgetting her name. Oh, my mind has been in a fog since I've been sick. Somebody please stick in chat the lady who was murdered by that Capitol officer on January 6th. It's going to kill me when y'all stick that name in there because I have it on the tip of my tongue. And there's a word for forgetting words. It's called lethologia. So I'm having lethologia. Ashley Babbitt. That's it. Am I correct? Was it Ashley Babbitt or is it Bobbitt? I'm getting close. It's starting to come into my noggin. Such power, Ashley Babbitt. So I did get it. It did finally come. Such power over governance, however, does not extend to federal office holders and candidates. However, there are ballot access laws at the state level that deal with federal office holders and candidates. Now here they're just saying that they can't enforce Section 3 of the Constitution when it applies to this. But why can there be such differing ballot access laws enacted by the states for federal office holders, for House of Rep, for Senate? How can that be? There's some implications in this decision that I think the Libertarian Party and other third parties can start to use for ballot access cases. Now, I know it's far afield because it's not dealing with the 14th Amendment per se, but I loved that sentence. Because federal officers owe their existence, and it does seem to insist here, it does seem to imply that the president is an officer of the United States, again, without saying it, though I don't agree with that. It does seem to be implying that. Because federal officers owe their existence and functions to the united voice of the whole, not of a portion of the people. Oh, it's just a portion of the people that are allowed to have their candidates on the ballot, though, as any third-party person will let you know. There's a lot more in here that we could really use for ballot access. We're going to be getting to it. I was like salivating when I was reading this. Powers over their elections and qualifications must be specifically delegated to rather than reserved by the states. As an initial matter, not even the respondents contend that the Constitution... And you notice I am skipping around. I'm just highlighting things that will give you... because we're not going to read the 11 pages of the majority and then the 9 pages of the concurring. As an initial matter, not even the respondents contend that the Constitution authorizes states to somehow remove sitting federal office holders who may be violating Section 3. And that is a really interesting point that never occurred to me. Okay, and it says this can hardly come as a surprise, given that the substantive provisions of the amendment embody significant limitations on state power. So that, to me, was a really interesting argument. So it's basically saying that the whole theme of the 14th Amendment is clawing back power from the states, as opposed to how we were originally formed as a country. So why would the states think they get some expansive power out of an amendment that's a clawback amendment? I thought that was a really, really interesting argument. I'm not saying I'm comfortable with that argument because I like more localization, but it is an interesting argument. It would be incongruous to read this particular amendment as granting the states the power, silently no less, to disqualify a candidate for federal office. They disqualify candidates for federal office all the time for third parties. I think JJ is correct that there may be some kind of like rabbit trail precedent created here. Granting the states that authority would invert the 14th Amendment's rebalancing, rebalancing my ass, of federal and state power. Nor have the respondents identified any tradition of state enforcement of Section 3 against federal office holders or candidates in the years following ratification of the 14th Amendment. Such a lack of historical precedent is generally a telling indication of a severe constitutional problem with asserted power. I'm going to give you a very weird analogy here, but I think people kind of like me for my weird analogies. There's a book, crap, what's it called? It's on interpreting history, and some principles of interpreting history. Like if you're trying to date a book that doesn't have a date in it, and the book purports to be the history of New York City, but it doesn't mention 9/11, you can pretty reasonably assume, as a historian, historical fallacies, that's the name of the book. You can reasonably assume as a historian that the book was written prior to that event, because that was such a significant event that silence there is actually proof. Because one of the historical fallacies that's dealt with in the book is that absence of something or silence isn't proof in some way. You know the, I'm trying to think of the way the expression goes, but actually in doing historical analysis, absence of significant things that you would expect to be in something that purports to be recounting an event is pretty important. So silence can in fact be proof. And I think that kind of forensic historical analysis is relevant here. And I'm kind of have that on my brain because I'm doing a presentation in Michigan this weekend on the interpretation of the Statement of Principles in the Dallas Accord in 1972, where we have to do some historical forensic document interpretation. And I do have a background in that. Some people don't know. I've written a biblical commentary on Matthew 24 where I really delved into church history to try to come up with a historically accurate exegesis rather than eisegesis of that passage. So all of my various skill sets are coming into play here. And it is an especially telling sign here because, as noted, states did disqualify persons from holding state offices following ratification of the 14th Amendment. Just checking for comments. Okay. That pattern of disqualification with respect to state but not federal offices provides persuasive evidence of a general understanding that the states lacked enforcement power with respect to the latter. That ties right into the historical fallacies example that I gave. The lack of them ever trying this before is evidence that they did not have that power, or that it wasn't a general belief that they had that power. Finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest. Here's my extra mic for a mic drop. Does it really now, Supreme Court? How about the way the presidential candidates for the third largest political party in the country, the Libertarian Party, routinely get screwed out of being on the ballot? How about that? Cash me outside, how about that? Really? Tell me about it. I need a drink because I'm going to start coughing. That got me upset, if you couldn't tell. I'm going to be sending this video over to the Ballot Access Committee of the Libertarian Party, which I'm on because I'm on way too many committees. Okay. Yes, I agree, Supreme Court. Now start applying that to third parties and ballot censorship. Oh, and you can see here, well, maybe you can't. So I highlighted, but then I put like a little bracket around this highlight, which meant I really thought this was juicy. And I forgot what it was, even though I read it 2 hours ago. Let's see what I thought was really juicy. The patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. In a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast. You want to know how many votes are not allowed to be cast for the Libertarian Party presidential candidate? Because we can't get on the ballot? Larry Sharp, and I think it was in California, I think his estimate is high. I can tell you what the Ballot Access Committee's estimate was and what his was. Either of them are well out of our price range. In order to get the presidential candidate as a Libertarian on the ballot in New York, Larry Sharp estimates will cost us $800,000 just for the privilege of being on the ballot when we're the third largest political party in the country and have fielded presidential candidates for 50 years and have earned an electoral college vote in the past. 1972, faithless elector, McBride out of Virginia. And we also had the first woman to receive an electoral college vote, thank you very much, which was also Tony Nathan in 1972. Screw you, Hillary Clinton. Went off on another bit of a tangent there. Now, the Ballot Access Committee is estimating between 250,000 and 300,000. Either way, it's well out of our pricing. But isn't that a patchwork framework? The ballot access laws in some states are just so ridiculous unless you are a Republican or a Democrat. It really is kind of analogous to Henry Ford saying you can have a Ford in any color you want as long as it's black. Here, you can vote for any candidate you want as long as it's a Republican or a Democrat. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. Oh, really? Don't I have a really thing here? Let me get up my soundboard, because my Stream Deck doesn't seem to be working. Where's my sound effects? I think I have yes, here we go. Really? Yes, really. And I need another one.
Make it make sense.
Make it make sense. The disruption would be all the more acute and could nullify the votes of millions and change the election result if Section 3 enforcement were attempted after the nation has voted. Now it's starting to get into the more specific to this case. But how is not all of that written applicable to ballot censorship as well? How is it not? Make it make sense. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates raise, Justin Carmen. Justin Carmen's from New York, so we're going to put his comment here. So Justin Carmen's from New York. 800K is almost double everyone else's estimates in New York. I did think it was high, quite obviously. But there will be a shortage of petitioners, and the paid ones will be fetching top dollars, of course, because of, RFK Jr. and the No Labels Party and the Forward Party. I got to put you back up here. So the New York Executive Committee estimates around 500,000. So you guys are estimating kind of in the middle between what the Ballot Access Committee was estimating and what Larry Sharp was estimating. In any event, all of those estimates are like ridiculous. Make it make sense. So it starts to go back into section 3. And then at the end, it says, and it talks about the concurring opinions that have dissents kind of buried in them. It says, it says, all 9 members of the court agree with the result. Our colleagues writing separately further agree with many of the reasons this opinion provides for reaching it. It says, so far as we can tell, and it's dealing with I think Sotomayor, Kagan, Jackson, and also Barrett, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. These are not the only reasons the states lack power to enforce this particular constitutional provision with respect to federal offices, but they are important ones. And it is the combination of all the reasons set forth in this opinion, not, as some of our colleagues would have it, just one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment the court unanimously reaches. So everyone reached the same conclusion unanimously, but they did get to it by different routes, or more narrow routes is more appropriate. So here is Barrett's concurring in part and concurring in judgment. Now, concurring in part, it's almost like a glass half empty, half full. If you only concur in part with the reasoning, that means you dissent in part. It's funny the way they really avoided using the word dissent here at all, but these are in fact partial dissents for the rationale, but not for the holding. Everyone agrees what the holding is. So Barrett says, I join parts 1 and 2B of the court's opinion. I agree the states lack the power to enforce Section 3 against presidential candidates. That principle is sufficient to resolve this case, and I would decide no more than that. This suit was brought by Colorado voters under state law and state court. It does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced, because this majority opinion kind of put some more boundaries around it that weren't necessary. And I think I agree with Barrett here. The majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. I disagree with him there. I don't think the court should take into consideration national temperature. That politicizes the Supreme Court. Not that part, I disagree with him. But I do agree with him that going beyond it is probably going to have ramifications, or definitely will have ramifications that they did not intend. It's almost like chaos theory. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. This is the message Americans should take home. This, though, that last part, that's just a political screed that has no place in a Supreme Court decision, in my opinion. So now here's the concurring in the judgment of Sotomayor, Justice Kagan, and Justice Jackson. Note that they did not see fit to title it concurring in part. So they really went out of their way to avoid the unspoken dissent part. I love, and this is what made me not mad anymore. And normally Sotomayor, Kagan, and Jackson make me mad, but they're the one who made me not mad, because I think something they said here was wise. Now, they were quoting Dobbs, but the quote they pulled out of Dobbs was very wise. If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. And that really turned down my personal temperature of being mad that they didn't settle the question that I was particularly interested in. Check this out. But they also say states cannot use their control over the ballot to undermine the national government. Well, what are you doing when you are, through ballot censorship, states denying people the choice to vote for the candidate of their choice? And they continue. The court continues on to resolve questions not before us. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed. I think they are right. And I normally don't think those 3 justices are right, but I think they're right. Now, here's where I'm going to disagree with them. It says Section 3 provides that when an oath-breaking insurrectionist, as if that's a bad thing, is disqualified, Congress may, by a vote of 2/3 of each house, remove such disability. It is hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority, God, they used the word simple majority. You know I die inside every time the word simple majority is used, could nullify Section 3's operation by repealing or declining to pass implementing legislation. Even petitioner's lawyer acknowledged the tension in Section 3 that the majority view creates. I disagree. I absolutely disagree. I find it really logical to require a supermajority to remove the disability, even though it would only take a majority to create legislation, because the supermajority is removing a disability, such a disability, from a particular candidate, whereas the legislation would be general to everyone, and the supermajority would allow you to pluck some out of that jurisdiction. So I think that is a nonsensical statement, unless I'm misunderstanding it by these justices. And it also says but then they go on to talk about how enforcement is done after criticizing the majority for doing that. So they're engaging in a little bit of hypocrisy here. All the Reconstruction amendments, including the due process and equal protection guarantees and prohibition of slavery, are self-executing, meaning that they do not depend upon legislation. If you thought that the majority opinion shouldn't opine on how it would be enforced, why are you doing it? Hypocrisy. Okay. And I think their implication is correct here. By resolving this and other questions, meaning going beyond the questions presented, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal office. It reaches out to decide Section 3 questions not before us. Well, you just did that, where I just read, but okay. And to foreclose future efforts to disqualify a presidential candidate under that provision. So they're low-key accusing the majority of, I think, of people trying to find another way to disqualify Trump under the same provision. Maybe not, but they are making a political accusation here. In a sensitive case crying out for judicial restraint, it abandons that course. I don't care whether a case is sensitive or not. I think their argument for judicial restraint was a good argument without appealing to whether the case is sensitive or not. It's kind of like my view, like when people go friendly amendment, It's an amendment. It doesn't matter whether it's friendly or hostile. It's still an amendment. It doesn't matter whether it's an asshole amendment or an amicable amendment. It's still an amendment. So who cares whether it's a sensitive case? If judicial restraint is... This is running a little, I'm sorry. If judicial restraint is what's required, it's required no matter the type of case. Section... I wish I needed alcohol at this point to read this next part. And we're on the last page, by the way. And I just want to take a look, make sure there's no comments that I missed. Okay. And remember, all super chats matter if you appreciate this kind of obscure going through this case. Section 3 serves an important, though rarely needed, role in our democracy. I'll zip it. The American people have the power to vote for and elect candidates for national office, and that is a great and glorious thing. I'll zip it. Let's say that that, in fact, is all true. And, of course, under the alleged system that we have, that is supposed to be true, right? Then why are you eliminating candidates from the ballot? Why does the Libertarian Party have to fight for ballot access every 2 years in a lot of cases, because there are federal offices, but let's just talk about the presidency, every 4 years, to the tune, if we want to get it as a libertarian in 50 plus 1, so 50 states plus DC, it can require $1 million easy. So sometimes we have to go the route of an independent petition so that our candidate appears as an independent and not as a libertarian. It is so ridiculous. I can't believe I've been doing this for an hour. I thought this was going to be like a 20-minute show. But you can tell I'm passionate. The men who drafted and ratified the 14th Amendment, however, had witnessed an insurrection and rebellion to defend slavery, and overreacted by putting this in the Constitution. Should never have been in here. They wanted to ensure that those who had participated in that insurrection, they could have dealt with it another way rather than any way. They could have limited it to that. There's a lot of other ways this could have been handled. And impossible future insurrections. Well, we see how that's abused, don't we? Could not return to prominent roles. Well, here's what's interesting. What about this great and glorious democracy? If through a democratic process the people want quote-unquote insurrectionists in power, why shouldn't they be able to have that great and glorious choice? Oh, it's only choices you agree with. I get it. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist, my God, from becoming president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. I think you're showing your hand and bias here a little bit, justices, because we would decide only the issue before us. We concur only in the judgment. Though I think ultimately, except for the points I pointed out where I think they went out of their tree a little bit there. I agree. Now, and thank you, JJ. I'm gonna put this on the screen. I could use all the compliments I can get when I'm feeling like crap. I'm surprised I got through this because I really am feeling like crap. Now, I heard earlier today, and I think it was on the Daily Wire, I'm not sure, where some sleuth, and I was laughing because this happened to me with something. Some sleuth said, if you look at the metadata behind this Supreme Court decision, you'll see that there were changes made where Justice Sotomayor at one point was dissenting, and that got removed, and salivating over this alleged conspiracy. At least this is the way the Daily Wire, I'm pretty sure it was the Daily Wire, said it. Now listen, if I were a reporter like investigating this, and I found some cool metadata, I'd get pretty excited over it too. So I think them like acting like it was ridiculous for some reporter to get excited they found some metadata is silly. I think that is something to get excited about. And the Supreme Court should make sure they're not releasing documents with metadata in it. I mean, to me, that's the bigger issue, isn't it? And I don't know the procedures, and I'm sure it's unique to each justice as to how they come to their opinions. I know, for instance, as a paralegal, when I'm drafting documents, so for instance, in a recent federal case, a trademark case that I'm involved in, where I helped draft some documents. Of course, the attorneys finalized and did all that. I'm not an attorney. I don't engage in the unauthorized practice of law, but as a paralegal, paralegals often do initial drafts, and then it becomes the attorney's work product after they review and make their changes. But I know in my legal writing style, I often have an idea for an argument or what I think the case law is going to show, and I will lay that out. But upon further research and talking with people and in interacting with the case law, I change my mind and I change the argument. And if you were to look at the metadata, you would see that. But it's not some kind of conspiracy of me trying to make the evidence suit my argument. It's me following the evidence. So maybe, perhaps, initially, Justice Sotomayor had a different opinion, and through reading the other opinions of the other justices and talking with the other justices and reviewing case law, she changed her mind. That happens. I know that's the way, at least I do my legal reasoning for cases that I work on. I outline what I anticipate my argument to be. But as I do further research and talk with other people and interact with the other pleadings in the case, I often change my mind and sometimes turn arguments completely on their face. An argument that I thought was a good argument later turns out to be a bad argument. So, while I don't think there's some great conspiracy over finding the metadata, I think it is really interesting that someone found metadata, that the Supreme Court doesn't cleanse its documents of metadata. Now, I didn't go and confirm that myself. Maybe that was all made up, but I did hear that reported upon. And I'm laughing about it because there was and if Adrian's watching this, he'll be mad at me. I wrote an appeal and this isn't in law, this is in my political party, but the Libertarian Party of California used to allow out-of-state members. So I was a member by paying dues of the Libertarian Party of California. But I hadn't reached a seasoning period yet to have certain rights. So I was at a convention where they deleted the entire platform, and it was in violation of their bylaws. So some members who actually had appeal rights appealed that decision to their judicial committee. I wrote the appeal for them. I couldn't submit the appeal under my name because I hadn't passed the seasoning period. But I certainly could assist members who submitted it under their name. And another member, I think it was actually a JC member, but it might not have been, thought they were being super clever by, and I probably have, I got kind of sarcastic. I know, me be sarcastic, that never happens. Went to the metadata and saw that the document was created by me. And I was like, okay, Sherlock Holmes, you caught me. It was no secret that I was writing the appeal, but what particularly made it no secret is I made no attempt to change my writing style. I have a very distinct writing style and phrases that I use all the time that anyone in the party who's used to hearing me or reading things that I write can know immediately it's me. For instance, if the phrase mining the subjunctive is used, everyone knows that's me because I use that phrase all the time. Now, I didn't invent it, but it's a favorite phrase of mine. And I do have distinctive verbal patterns. So when I wrote this appeal, I made no attempt to change any of those verbal patterns. Anyone reading it could tell I wrote it. So I was like, congratulations, Sherlock. You figured it out. If it wasn't for you and those darned kids, for that dog and those darned kids, I would have gotten away with it too, Scooby. So anyway, that's why I thought it was funny about the about the metadata. I want to see if I can find that. So this would be on Lpedia. We're done talking about this case, so anyone who's not like interested in LP stuff or me rambling, you might want to drop off. But this is, I think, kind of interesting, and I do appreciate everyone who was watching. Again, I had a ton of viewers. Please hit subscribe, because I do unusual content like this quite frequently. So I'm looking for Libertarian. So I'm on my Lpedia right now. Libertarian Party of California Judicial Committee, because I'm pretty sure my sarcastic letter is in there. Yes, May 2019 appeal of convention action regarding platform. So let's see. Appeal website. Submissions to the committee. Comment by Karen Ann Harlos, and supplementary comments by Karen Ann Harlos. Because I wasn't able to submit the appeal, but I was, as a member, able to comment. Oh, so I said, appellees have turned a platform dispute into a fascinating I Spy episode of Who Killed Mr. Body in the library, and have concluded that I did by examining document metadata and unusual style of prose. I could have saved everyone a lot of high drama just by being asked. I wrote the document. Appellees seem to think that this is some feat of forensic sleuthing that would never have occurred to some wily ghost author who wished to remain unknown. I purposely did not change my style, and in fact commented to multiple interested people that it would be obvious who wrote the bulk of it. I did not examine the final brief to see if anything was added, since my contribution was given with free rein to use as much or as little and to edit away to anyone's heart's content. I am a paralegal with extensive experience in fraud investigation, so I am very aware of metadata and have a document metadata cleaner. I did not use it. I have extensive knowledge of the forensic methods of determining actual authorship of texts, i.e., in my case, it surrounds the argument over whether or not the Apostle Paul wrote the pastoral epistles, and one of the key data points is similarity or dissimilarity in style and language. I did not lose all of this knowledge in a fit of sudden dementia. Thus, I obviously did not and still do not care who knows that I assisted in the brief, and depending upon whether or not it was edited or added to afterwards, could be its only author. I am also the only author of multiple court filings that are signed by the filer, i.e. the attorney. My preparation does not make those filings mine. My work product is subsumed by the signatory. So I got a little feisty in that one, because let me see if I can find where it was like the aha, this was written by Karen Ann Harlos. Yeah, here's the response. I want to see if I can find the word metadata. Yeah. So here's the response that I was responding to. Document metadata identified Karen Ann Harlos as the person who, at the very least, assembled the appellant's complaint. More likely, she was the principal author, given that the appeal mirrors her comments during convention, her Facebook videos posted the day after convention, and her unusual writing style. She is a resident of Colorado who, during this portion of the convention proceedings, said she had just joined the LPCA that day. I was like, way to go, Sherlock. But obviously, if I put in the appeal the exact comments I put on video the day after the convention, I was not trying to hide that I wrote it. That was just fun, though. That's the type of fun we have in the Libertarian Party. I've gotten a little less feisty since then. What happened in 2021, though, I still think an absolute travesty. I don't claim perfection in all of my behavior, and I did get out of hand in some points. We all do. And I hope we all mature from that. So I try to save more of my feistiness now for the state. But libertarians endorsing status things like the COVID regime and things like that the last LNC completely dropped the ball on, I make no apologies for being harsh about that. Okay, that is the end, and it's driving me crazy that I only have polish on one hand, and it's probably going to be that way until tomorrow night. And the tips of these fingers are dyed pink from me scratching my head. This pink, like, sheds on everything. Pillowcases, towels, let's see if I can get some on the paper. No, actually, I guess it's coming off a little bit. None came off on the paper. All right. I hope you all have an awesome night. Probably will not be doing another stream till next week because I am going to Michigan. But I am going to try to have Angela McArdle and Hannah Goodman, who are also running for, because I am rerunning for LNC Secretary. For some reason, some people didn't know that. I declared back in January. It's not a secret. Hannah Goodman, who is the Colorado State Chair, is running for National Vice Chair. And Angela McArdle is rerunning for National Chair. And the three of us, the three ladies, we are going to probably be doing a show together. I'm thinking of next Friday, but I don't know if Angela and Hannah are available. But that's when I'm available, and I'm the one with the crazy committee schedule. Okay, I hope you all have an awesome night and that you enjoyed this show. Mi guapas de libertad.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians and choose to be an accountant because it's safe.